How can I express my gratitude?
How can I express my gratitude
for all the many things,
you
Father, you done for me, yeah.
Words are not enough to say thank you.
So Lord, you are,
Lord,
you're
my everything.
See, I call you Jireh.
You're my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
You're my everything.
I call you Jireh.
Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
You're my everything.
Uya matinyina. Uya matinyina. Uya matinyina. Oh, uya matinyina. Yeah, so uya.
Moya matinyina. Moya matinyina.
Yeah.
Moya matinyina.
Oh, uya matinyina. Say, I call you Jireh, say.
I call you
Yeah.
Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will you make one cover? 1, 2, 3.
Oya mi kwako bila mabani, umenida so.
Yeah.
Oya maua umeniteka. My life is in your hands, I can't live without you.
I can breathe without you, say.
I can breathe without you.
I can move without you, Lord.
I can move without you.
Hey. Who am I without you?
Who am I without you?
Say, I can live without you, yeah.
I can live without you.
I can breathe without you, Lord.
I can breathe without you.
I can move without you, yeah.
I can move without you.
Who am I? Who am I? Who am I? Who am I? Hey, we are mounting now.
Oya matinyina. Oya matinyina.
Oh, so oh yeah,
Oya matinyina.
oh yeah,
Oya matinyina.
so oh yeah.
Oya matinyina.
Okay, lovely people. Thank you so very much. And another Saturday afternoon, and we're so happy to come your way again on the program, The Community and the Law. My name is Ulriku Frimpon, and I have the duty and the pleasure to be hosting this program between now and 6 o'clock here in the UK. And we have a very interesting and important topic to be discussing. And I am going to say a very big thank you to BWF Solicitors for supporting the program. We're live on BW TV, BW Radio, live on BWF Solicitors Facebook page and all the social media platforms. BWF is a trusted friend when it comes to legal matters here in the UK. And we believe that when it is that we have a trusted friend like that, you can go to them every now and then with your matters. They work Mondays to Friday between 9:30 in the morning and 6 o'clock in the evening. Call them on 0208 493 7340. We're right into the thick of it. Let's say thank you to BWF Solicitors. And when we come back, I'm going to help you answer a question. Now, you're a student who's come from outside of the UK to study here in the UK. And for one reason or the other, you are not able to complete your studies. Now, how can you remain in the UK legally when you find yourself in that situation? We'll be right back. BWF Solicitors is a proud sponsor.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Thank you very much for sticking and staying, and of course, liking the page, setting your notifications on, and of course, joining us on the program, The Community and the Law, on a very lovely Saturday afternoon here in London. Once again, my name is Osu Frimpon, and I have from BWF Solicitors my brother and friend, lawyer Charles Asma, who is going to help us do that discussion on the very interesting topic that I have posed. The question is, if you are a student and you have, for one reason or the other, not being able to complete your study, what happens to you so you can legally remain here in the UK? Asma, good afternoon once again. Okay. All right. Yes, I can hear you now. Good afternoon.
Good afternoon.
Thank you very much for joining us. How are you doing?
Very well, thanks. How are you too?
Yeah, we're so happy to have come to your world, and listeners and viewers are very grateful for your time as well. It's a lovely Saturday afternoon, and people are having all their barbecues and the rest of it. But you have chosen to sit with us and talk about what our options are to legally remain in the UK if, for instance, a student is not able to complete their study. So we'll be back to you. But let me quickly take this out of the way. Let's get our nuggets out of the way for our viewers. The holiday pay. Last week, if you do remember, if you were on the show, you remember we were talking about your holiday, your annual leave that you need to take, and for the reasons why you need to take your annual leave. Now, if you do take your annual leave, are you supposed to be paid for the holiday you have taken? And if for one reason or the other, you're not able to complete your holiday allowance in the financial year, what happens? There's a case. Connor versus Chief Constable of South Yorkshire Police 2023 case, EAT 42, that's what it says. And it reads, an employee has to receive the same daily rate for holidays, irrespective of whether they take it during employment or receive it as a payment in lieu once their employment ends. Last week, I think we did mention that some organizations do not really pay for holidays that you have not taken. So if you do not take it one way or the other, you lose it. But if your employment ends and you have holidays in the bank, let me put it that way, what happens to it? Now, let me go to my brother to kind of explain to us holiday pay and on taking holiday pay, how is it? How is it done? How does the law see it? And how we are going to look at it. Layasma, take us through.
Thank you very much. Viewers and listeners, very good afternoon to you, wherever you are. Coming your way from the studios of BWTV. So today we are looking at important aspect of the law, holiday pay, and this affects all of us, be it employee, worker, agency worker, or what have you. We all must have time to rest, and that is statutory. So we are looking at the context to holidays. We are aware that the Health and Safety Act 1974 requires that our health and safety remains paramount to ourselves and also our employers. And again, within the Employment Rights Act 1996, employees are supposed to take a holiday when it is due. And the only time the holiday can be deferred is when it is in the interest of the organization to do so, and the organization has agreed to the deferral. Now, we are looking at an instance where holiday is deferred, and for whatever reason, the person has to be paid the holiday. How is it calculated? How does it work? Now, the law says that an employee has to receive the same daily rate for holidays, irrespective of whether they take it during the employment period or not, whether it's taken in lieu once the employment has ended or not. And we are looking at the case of Connor vs. Chief Constable of South Yorkshire Police, and this is a 2023 case. Now, what this simply means is that holiday ought to be taken, and when you do take your holiday, you have to be paid for the holiday. What it means is that when you're on holiday, your employer cannot say that you're on holiday and therefore you are not going to be paid. You will be paid. What if you don't take holiday? If you do
Mhm.
not take the holiday, the employer will have to calculate the period that is not the holidays that is still accrued and pay you, provided, and here is very important, provided the employer agreed for that deferral. If the employer does not agree and you decide not to take the holidays, then it is not the case that you accrue the holidays deliberately with a view to create income or money out of it. So, in terms of your contract, it will specify when you have to take the holiday, and if you do not take your holiday, how the holiday payment could be given, provided the employer did not agree to that. So these are the things that we have to be careful for. And when the matter goes to court, the first port of call or the point of reference will be the employment contract. And if it is silent, we look at what the law say, what we call the statutory um, implied expectation. So first off, the contract of employment, and secondary, the statute, what the law says. Then we, of course, we also look at case law. So that is the gist and what the nugget is actually telling us.
Well, let me find out if, for instance, for some reason you're not able to take your leave. Does it have to be an internal arrangement with your employer, or the law has a backing for the employee to, or even force the employer to make sure that leave that was not taken is catered for?
So the employee must take their leave.
Okay.
It's statutory. You have to take your leave. And if your leave is whatever days within the year, you have to check it so that you can take the leave. If
Mhm.
the employee is not, the employer has a duty to press upon them to take the leave. And if it is not still taken, it cannot be rolled over or it cannot be converted to money. The only condition here will be that the employer has agreed for the employee to defer the holiday. Maybe this employee's skill set or the job they are doing so crucial at the time that they wish to take the holiday that it is important for them to be requested, and if they agree, they defer the holiday. So if that is deferred, then the employer will be um, by law required to pay the employee for that deferred holiday, or it can be rolled over for the next period of holiday, or the arrangement. So the internal arrangement is there for the employee who by way of necessity has to defer his or her holiday.
Okay. Okay.
But the employee cannot choose that, oh, I don't feel like taking my holiday and therefore I'm going to convert it. Or if I don't take it, it will be converted to money. And therefore, let me take my salary and still sell my holiday to the employer. That it doesn't work like
It
that.
doesn't.
And
Can
they
can
end
the, can the employer compel the employee to take holiday?
Yes, the employer must tell the employee to take holiday. And as a matter of fact, if the employee decide not to take holiday, there should be a reason why they cannot take holiday. And to an extent, the employer can sometimes be asked to explain why the employee did not take holiday at the time they needed to have taken the holiday. So yes, employer is supposed to, if should I say, remind the employee that they are due to take their holiday, and if they don't, they may lose it.
If they don't, they may lose it. So the case that lawyer used as backing for the discussion we have just had is Connor versus Chief Constable of South Yorkshire Police, and it says an employee has to receive the same daily rate for holidays, irrespective of whether they take it during employment or receive it as a payment in lieu once their employment ends. And with that, we will take another quick break and we come straight into our discussion, which will be what happens to a student when, for one reason or the other, is or she is not able to complete his studies and risks not being legal here in the UK. We'll be right back.
Private Client Services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing, BWF solicitors. Let us take care of probate.
Welcome back. Thank you very much for sticking and staying, and of course, having faith in us to enjoy the discussion we are bringing you. We're live on BWTV, and as I mentioned earlier on, my guest is Lawyer Charles Asma from BWF Solicitors, who has graciously this afternoon joined us to help discuss the topic, what are my options when I'm unable to complete my education here in the UK, for me to remain very legal here in the UK. Lawyer Asma, once again, good afternoon, and thank you for your time. Now, people come in to study. As students, let's briefly ask, what kind of rights do students have? If a student is admitted to any institution of study, does it make the person a legal citizen or resident of the country?
Good afternoon, viewers and listeners. Once again, we come your way. So the topic is already echoed. I am a student. I am here, foreign student, studying in the UK. For one reason or the other, and we look at some of those reasons or factors that may impede our ability to, with the best of intentions, complete our course. And if that happens, what do we do? How do we still remain and regularize or remain legally? So, a foreign student is a student who has gained admission to study in the UK, and we are looking at the UK context, to study in the UK and for a period of time for that studies. It could be less than a year, it could be a year or more than a year. Either way, the student will remain a foreigner, so to speak, because that person is not a UK citizen, or the person has not attained indefinite leave to remain. So what they have is limited leave to remain student visa.
Mhm.
The period of studies will be calculated so that the visa will be enough to cover your studies. So if it's a 1 year program, you may have your leave to cover 1 year plus 3 months, so that you finish, you organize yourself within the 3 months and you leave. Or 1 year plus 6 months, depending on what the caseworker offers. Whatever it is limited leave to remain. As a limited leave to remain student, foreign student studying in the UK, holder, what you have in terms of right would be to work. And your work, as we know, is 20 hours during the term time. Term time means during the time that you have to be in university or in school to study. And during holidays, you can do unlimited hours. Now, these are the conditions. You also have to make sure that once your course is over, you organize yourself, you graduate, and you go back to your country. The government has proposed that those who wish to stay on after the course can apply into the postgraduate scheme so that the person can find a job, gain transferable skill and experience so that when they go back to their home country, they can become fit for purpose, so to speak, in terms of contributing to the development of that country. But mind you, it's a very clever way of saying that once you have completed your course and you have fresh skill and ideas, stay on and help us. So once they are staying on, they are also gaining experience, they are also gaining a skill.
Okay.
That opportunity does not lead to settlement. So it's a temporary leave. It doesn't add to anything. Once you finish that period, you go back. That means you cannot even extend on that. Now, let's assume that for this individual we are looking at, when he or she entered, for whatever reason, they could not complete the course.
Okay.
What are some of these reasons? It might be that in the course of their studies, they lost the sponsor, be it their parent or the family member, they lost that sponsor. And if they lost the sponsor and they are not able to meet the financial obligations in terms of their fees, their study materials, accommodation, and what have you, they cannot continue the course. This person has potentially explored other avenues in terms of speaking to the university welfare unit, in terms of appealing to other charities for support. It didn't work. And therefore, the person necessarily have to stop or has to curtail the studies. Once that happens, the leave is no longer going to support the person's stay, especially when the university finds out and informs the home office that this person did not complete or has not or did not pursue the course. They will take steps to curtail the leave or cancel the leave. So let's assume that this person, because did not complete the course, the leave is curtailed.
Okay.
That's one option. What does this person do?
Do right.
Or this person did not complete the course or cannot pursue the program because of the reasons we have alluded to.
Mhm.
The leave is not cancelled. What can this person do?
Do.
So we have two
So,
options.
so obviously we have two options. Yes.
Yes.
You are not able to do that. The leave is cancelled. What do you do?
Yes.
You are not able to complete. The leave is not cancelled. What do you do? Let me just take a step back and look at some of the reasons that may prevent people from completing their course. You talked about the sponsor not being there anymore. The person probably may have found himself or herself in a circumstance here in the UK. For instance, a female person becomes pregnant and is not able to continue that. Would that be counted as a legitimate reason?
So we are looking at reasons why somebody may not be able to continue.
Mm.
But if somebody is pregnant and they are able to pursue the courses through other flexible means with arrangement with, by the university or with the university, then they will be able to continue. So I will not say that pregnancy is 100% reason why somebody may not be able to complete a course.
Right.
But I am inclined to say that potentially if somebody sponsor or somebody is not able to financially meet the school fees obligations,
Mhm.
then they cannot complete the course. If the parents that were there to support the fees are no longer there, or if whatever, even if it was the person's own money and the person is no longer able to have enough to pay for the fees, they cannot. If the person is able to afford the fees, and by pregnancy there is some sort of hiccup, then it's a matter of potentially they will complete the course, but it might be that the time duration within which they have to complete may be longer than usual. But that is an arrangement the person can have with the university as to what can be done. But if you can't pay your fees, that one, more or less, you've reached the point where you cannot complete the course. For the university will pursue it.
Can then somebody say that I am not in the right frame of mind? My mental health is not that good and at a level that I would be able to study. Would that be considered?
If illness has become a factor impeding the person's ability to complete the course, as I said, these are special circumstances. Illness, pregnancy, and other humanitarian or compassionate factors, maybe loss of parent in the
Mm-hmm.
course of bereavement, so to speak. All these things are factors that some universities have arrangement for. And so
Okay.
when that happens, the person will go through counseling, and the person may be given some level of extension so that they can complete the course. If the course is to be completed within a year, and for these factors, they may say, right, you have to complete within 6 months, within 1.5 years, or
Mm-hmm.
within 2 years. So these are arrangements that can be put in place. Yes, they are necessary factors, but I must say that these factors may not necessarily prevent the individual from
From
completing.
studying. Okay. Is the university compelled to alert the Home Office whenever there is a variation in the person's circumstance?
If the circumstance is something that the university can accommodate, they do not have to tell the Home Office.
Okay.
But if the person did not report to start the course, or started the course but stopped without alerting the university or without apparent reason, then the university is inclined to inform the Home Office that, because remember they are the sponsors and they have obligation to manage you, so to speak.
Mm-hmm.
So if you are not manageable, quote unquote, then they have to alert the uh, the issuer of their license to be able to sponsor you, that this person that we are managing has not been able to because of whatever reason, and they tell them.
Okay.
And once that happens, it might be the case that they will take steps to curtail, but they will alert you that this is going to happen, so you have to find a way to um, mitigate that effect.
Okay. Well, if you just joined us, Lawyer Charles Asma is our resource person from BWF Solicitors, and we're looking at what the options of remaining in the UK legally are if one is not able to finish their studies here in the UK. Now, he has given us some of the reasons and the scenarios where students may not be able to complete their studies. Now, we're moving the discussion forward and we're going to look at what happened. Remember earlier on, Lawyer Charles Asma mentioned that there could be two situations. One where the university or the institution has reported to the Home Office and your leave is curtailed, and one where it has not been reported, your leave is not curtailed, but you are not able to complete your study. What happens? I think we'll take the first one first and ask Lawyer to help us with that. Last one, if the organization requests or tells the Home Office that they are going to curtail my stay in the UK, and that puts me in a precarious situation. What do I do?
So the university has reported the student absence
Yeah,
to the Home
the Home
Office.
Office. Yeah.
Home Office will alert the student that this is going to happen.
Hmm.
So they will be given um, time frame. It
Okay.
doesn't matter how long they give you, but you'll be given time.
Okay.
And as soon as you do receive that alert, you have to take action. What they will tell you is to see if you can transfer it to something else,
Okay.
what we call the switch. prior to 27th of July 2023, this individual could have switched from student to um, skilled worker.
Mhm.
However, at the moment, the law has changed, and therefore the person cannot switch, because what the new law has stated is that if the student wants to switch, they must first complete the course.
Okay.
So if you have not completed the course for the good reasons you have given, it doesn't give, even your reasons are good, it doesn't give you exemption from the position of the law. So from 17th of July, students who have not completed a course cannot switch to skilled worker.
Okay.
That is
Now,
one.
then it makes it difficult for students for whatever reason, legitimately, they have not been able to complete their course. Your institution has reported you cannot switch. How do you remain legal?
So this person has leave. Um, they are looking at one option is taken away, so they cannot switch. But the law at the moment has not touched a dependent of a student.
Okay.
The law has not said what will happen to, or what the dependent can do and cannot do.
Okay.
It's all about the student, the main person. So if this student has a partner whom he or she entered the UK with as a student dependent, and they are not, he, the main student, is not able to, for whatever reason, maybe intended to switch because they feel that, right, you know what, I want to maybe um, convert work and go back to study
Hmm.
by making a new application, having raised some funds because my sponsor is no longer available or alive. They cannot do it, but the law does not tell us what happens to the dependent. So we assume that the dependent can take the lead and become the main person in terms of the dependent wishing to transfer or switch their leave.
So what can they switch to? The dependent.
So if the dependent, for example, remember the leave hasn't been curtailed or cancelled. Even if it is cancelled, you've been given notice that your leave is going to be
So they
curtailed.
will have to. They,
If that
in the
happens to
common
you,
person's parlance, sort yourself out.
is that sort yourself out. That's what they will tell you. Sort yourself out.
Hmm.
You can't sort yourself out if you want to transfer to the skilled worker route, but your dependent can.
Okay.
If your dependent can and they meet the requirement of the application, then the dependent can transfer. And once dependent transfers and becomes the main sponsored worker, you, the student who has found him or herself in this situation, becomes the dependent of this person, your dependent, who has now become a skilled worker.
Okay.
So more or less, you are switching it around. You are changing positions,
Changing
literally.
positions. Right.
Yes, so that is one thing. The law has not, at least more or less, that the law is still flexible in terms of dependence. So that's one
Okay.
option. The next option is that while the person is a student
Hmm.
and the person has, let's say we have two people, we have a man and a woman. So let's take it intense.
Okay.
Let's take it intense. So this man is in the UK student. This
Mhm.
man, whilst in the UK, has fathered a child,
Okay.
because the law doesn't say you can't father a child. So if the person has fathered a child and the child is a qualifying child, i.e., a British citizen by operation of Section 1(1) of the British Nationality Act,
Hmm.
or by operation of Appendix EU, the child is a EU child and therefore has either pre-settled or settled, then we are saying that this child is a qualifying child.
Okay.
And as a qualifying child, this person who has become a father to this child can rely or depend on this child to make a direct access application if they don't live with the child. What then happens is that because they have to be able to support the care of their child, the rules allow him to be considered for 2.5 leave to remain under Appendix FM. So here, the person will migrate from being a student to being an Appendix FM father or parent to a British or a qualifying child, so to speak.
Okay.
Now, this option
Mm-hmm.
applies to both the person who has had the leave curtailed or leave still valid. It doesn't really matter. Once
Okay.
you have right to apply as a direct access father of a qualifying child, you can transfer from here to there.
I'm not saying that people should do that, but if it does happen that um, the female spouse, for instance, happens to also bear a baby for a qualifying partner who would father a child for this person, and the person is either settled or a British citizen, do those rights transfer to this female as well?
That is where the law becomes uh, contentious. Yes, so you realize that when I was touching that part of the law, I separated the two adults,
Right.
the man from the woman. So I didn't say if the student or the partner. I said if the man becomes a father. Now, what if the woman becomes a
Becomes a
mother?
mother. Hmm.
What the law says that having married already and living with your husband, whatever you accrue from outside is given to the husband you are living with.
Okay.
So this female student, having fathered a child for somebody, mothered a
Mother a
child,
child.
so to speak, for somebody else, the child will come home. She will bring the child home to the partner or the student partner, so to speak. If the student partner has nothing, then unfortunately the child will have nothing, and therefore the mother has nothing.
Okay. I'm looking at a scenario where partners have migrated. One is a student, one is a dependent. Now they come to live in the UK on a 3-year course, which gives the um, main applicant or the student 3 years to remain in the country, and the partner also depends on that. If they live here for about a year and the marriage breaks down, what happens to the partner that's the dependent? And in the situation where one father's a child or one mother's a child, what would their situation be? I hope you get my scenario. The
All right,
marriage
so
is
let's
broken
deal with
down. There's a
let's deal with the
divorce.
first part. Let's deal with the first part, then we
Okay.
take the second part.
Okay.
So the first part is where the marriage is broken down
Hmm.
midway, and it depends on what now has happened. Let's assume that this has led to divorce.
Okay.
Once there is divorce, there's total separation.
Hmm.
So the mother or the father, depending on whoever, the dependent who has separated from the main student cannot continue to have the same right as a dependent of a student
Okay.
because you've severed that relationship and therefore
Relationship.
the
Right.
right is taken away.
Hmm.
So that is what happens to this person once there is divorce.
But then
Now,
that person can salvage his or her situation in any way.
so once there is divorce, what we are saying that your right as a dependent of a student is not there anymore.
Anymore. Hmm.
What can you do? Will be anything else. Now that you have divorced and you are free, once you have mothered or father, well, so usually the mothers, if the mother has now gotten pregnant for somebody and the person is British or has indefinite leave to remain, then the child takes after their father.
Okay.
In this case, the mother doesn't have to bring the child home because the person that the mother would have brought the child to is no
It's
longer
no longer
the
the
husband.
married partner. Okay. All right.
Exactly. And therefore, she's free to live, quote unquote. So then,
Scenario where a student their course.
i- your line is, if you can check,
Say again.
it was muted. I
Oh,
wasn't,
okay. Can you hear me now?
I can hear you now.
Okay. Yes, I was addressing.
It's gone. Well, it's gone. It's muted.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA regulated professionals, transparent pricing, BWF solicitors. Let us take care of probate.
Okay. I think I'm clear now. Well, we're right back. Thank you very much for your patience. A little technical bit here, but we've gotten it sorted. Lawyer Charles Asma was explaining to us what the options of remaining in the UK legally are. Everyone could not finish their studies here. And we've looked at the scenario where the institution has reported to the Home Office and they have warned you that they're going to curtail your leave to remain in the UK. And we have extended the scenario to other areas. Now, let's look at the second one that lawyer mentioned earlier on, that you have not been reported to the Home Office yet, but you are not able to complete your study. In that situation, what does one do?
So you have not been reported, but
Mhm.
again, we want to know whether you still have leave or not. If you still have leave, then that covers those who have leave. Let's assume that this person's leave is already exhausted because they've been around for more than a year and they couldn't complete the course, and yet they have not been able to do anything to regularize. What can they do? The options are stay on and fight or go back to your home country. If you are choosing to stay on, as we have earlier mentioned, you can, whilst here, if you become a father to a British child or a child qualified under the rules, you can make an application that as a father or mother, depending on if there is no marriage situation, then the mothers can also have the same um, consideration. Then, having had a child in the UK whether you are living with a child or not living with a child, you have to prove that though you are not living with a child, you have direct access. Direct access means that you still are in the life of the child and playing active role in the child's life in terms of child's welfare, child's physical, emotional development, and support in terms of financial, emotional, psychological, on all aspects of support. Then we see the law sees you as a parent of that child. And as
Okay.
a parent who has access, direct access to the child, you can then, in the interest of your child, seek for regularization so that you can continue to support the care of your child. And this will also come under human right considerations. Again, if it is a mother, mothers can also become can mother the mother can have the child living with the child, but the father may live elsewhere. If the mother lives with the child, the father lives their life elsewhere, but they are in the life of the child, or they are not in the life of the child. If the child can trace his or her citizenship to that father within the rules, then the child becomes a qualifying child. If the child is a qualifying child, the mother who has the qualifying child can apply for consideration for the leave to be regularized. If the person already has something, then they can convert. If they have nothing, they can make an application again for 2.5 consideration.
Well, you said that the person can stay on and fight. So once that situation arrives, the person is illegal and would be avoiding the law enforcement to find something to really do and regularize. In that situation, if the person doesn't find anything for say a year, two, then they may have to be hiding, playing the hide and seek until they achieve that long stay for about 20 years, isn't it?
Well, if the person is choosing the last option,
Mhm.
which is 20 years long residence, but mind you, we don't even know what's going to happen to this law after 5 years or after 10 years. It might be
Mhm.
that they're going to change it from 20 to something else. So somebody who has just been around for 2, 3 years, if they are going to wait, of course, they'll wait for 17 or 18 more years. But what if by the time they are about to, the 20 has become something else? So the person has to explore other options they have and leave the long residence option to become the last option, so to speak.
Okay. Well, if you just joined us, the lines will be active very soon. Let me let you know that you can send a text to us on 079. That's for WhatsApp 0795042278, or you send a text to 0739920848 0739920848. That's the studio number. You can call on that number as well, and we'll pick up for Lawyer Charles Asma to address your question. It could be anything legal, but on our topic this afternoon, you can still call in and ask your question. WhatsApp and voice notes 0795042278 0795042278. What are your options when it is that you are not able to complete your education here in the UK, haven't come in as a foreign student? What do you do? Lawyer Asma has explained the various scenarios, and we will be taking your questions and concerns now. But before then, Sandra Fraser, you are online. Thank you very much, Sandy. Lyrical Black, good afternoon, Uncle Kwiko and Lawyer. You say, Amateur, great job. Thank you very much. Ademununkum is watching. Diana Dankwa, you are with us on here. Maxwell Kofiba, Ricky Ebotre, Kevin Asamoah says, good afternoon, Riku and Lawyer Charles. I greet you all. Yes, everybody on here is responding. Thank you. Eben, Greek word, then Lawyer Charles Asma. Greetings from Eben to you. Ademununkum is advising, share the program. Tilly Duma is watching. Chiwo, you're watching. Lovely family, you say, Tilly. Margaret Dumensa is online. Nana Sapon, Nana Bob, Ezekiel Johnson. We also have Chiwo. Lawyer Chiwo has brought in a question. Let me quickly read that for consumption. It says an EU spouse passed away on the 16th of July. This year. She entered the UK on the 18th of October 2022. She came with 6 adult children on the EUSS family permit. Please, what becomes of the adult children in the UK and what becomes of the adult children in Ghana and grandchildren of the EU spouse in Ghana in terms of application to enter the UK after her passing? Well, somebody came to the UK last year. Unfortunately, about a week or so back, the person's passed on. The person entered the EU with 6 adult children on the family permit.
Enter the UK, you mean?
Yes, UK. So the question is, how do the other children have any leg to stand on, as we would put in our local parlance?
Right. So, if I get it clearly, the EU national has dependent children,
Yeah.
and all these dependent children were living with, is it him or her, whatever it is,
Well,
in the
yeah.
UK,
Yeah.
living with her in the UK.
Yeah.
The mother is dead.
Yeah.
What happens to these children in terms
The-
of regularizing, in terms of their stay? I
Mhm.
suppose at the moment they are on pre-settled status.
Well, we can assume so.
Yes. So if they are on pre-settled status, what happens when they are going to extend?
Mhm.
The law says that having lost your mother, the EU national, there is an intervening factor. The intervening factor is death. And if the children can prove that the mother that they depend on is dead by way of death certificate, they
Okay.
will use that to continue the application or to make the application when the time is due. And that is the retention of right application.
Okay. You can also call 07399208 or send your question to the chat, and let's pick the one up for lawyer to address for you. You can send your WhatsApp messages to 07950422-780. Please, I would like to ask him questions regarding the new changes. I don't know what new changes, my friend, you're talking about. Do I need to book an appointment, please? Well, if you are live with us on the program, you can call in and lawyer will handle that for you. I don't know what kind of questions you have, but you can still book an appointment and go and see the lawyers at BWF Solicitors. I'll want to reiterate that they work Monday to Friday between 9:30 in the morning and 6 o'clock in the evening. Call them on 0208 493 7340 0208 493 7340 or 077 127 61884 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Lawyer, if, for instance, the school reports you to the Home Office and they give you a certain number of days for purposes of our discussion, let's say for 90 days, and you are not able to sort yourself out, can you be deported?
Right. You use the word can, and because the word is can, yes, the law allows for your removal
Okay.
because you are illegal. But I do also know that there are people, that's why the law allows for long residence The law make provisions for people who are illegal in the UK and they want to regularize. So
Okay.
it's a matter of the individual seeking advice early enough so that they can take steps to act on their situation.
Okay. There's a question here, and it says, do what options does one have in legally bringing a non-biological adopted son or daughter to the UK? A non-biological adopted son or daughter to the UK. What are the options?
Right. Forget about biological.
Hmm.
I have an adopted child. Can I bring him or her to the UK? The answer is yes.
Okay.
If provided you have gone through the process to legally adopt, and it's a court process. So you just have to make sure that the adoption process was valid and
Hmm.
that you have been issued with adoption certificate by way of court order. You have become the person with parental responsibility for this child. And again, this child must be a child, and a child is defined under Appendix FM as somebody under the age of 18.
Hmm.
And the EU law is 21 or before 21.
Okay.
But that is even with the EU law and the EU, children can even be adult children, but you just have to show dependency. Unfortunately, that flexibility is not available under Appendix FM. So if you have adopted child, yes. If you want to bring the child to the UK, make sure you do so before the child turns 18.
Okay. 07399208 WhatsApp, WhatsApp messages, voice notes, 0795042270. Now, what happens to somebody who is not able to complete the initial course that they signed on to, but would want to have, say, a gap year and sign on to a different course? I'm assuming it would be within the same university, just like different faculties. What happens to such a person?
Right. Now, we will have to understand what gap years are for.
Hmm.
A gap year is opportunity for you to explore other things by way of developing skills and talents and coming back to continue your course so that you come back to the course with some level of transferable knowledge and skill to
Hmm.
enhance the course that you are, your knowledge and understanding and participation on that course. But that is for those who have the flexibility to do so. You are a foreign national. You make an application for a 1 year course
Hmm.
or 2 year course or whatever the duration, you were admitted to come and study.
Hmm.
And you've been told that you cannot work during your during your school time. And of course, you cannot work because you are here to study, first off. And you can work 20 hours because the law knows that you need some support financially. So 20 hours flexibility. If you're going to take gap year, what it means is that you are no longer going to study and you are going to do something else. You don't have that condition attached to your course. If you're a foreign student and your course allows for work experience, then the school will arrange that during the period you have to be studying, not taking a whole period off and coming back. And therefore, that flexibility is not open to foreign students. So if you're a foreign student, you can't take a gap year.
But I've looked at, or I've found myself in those circumstances we explained earlier on, health reasons. My sponsor is not around. I am looking for somebody else to help sponsor my course, or my financial circumstances have changed, even though I am the one catering for myself and the rest of it. Can't I ask for a relief period so I can sort myself out? Can't
That
I
is not
arrange with a school?
that is not a gap period or year.
Okay.
Call it a mitigation period or relief period, however you describe it.
Hmm.
But this is where you have to act within the welfare system of the university.
Okay.
If the university allows that, then great. If the university thinks that that's going to interrupt your study and therefore you have to defer and come back, then you have to defer. What it means is that you are deferring your admission, not your leave.
Okay.
Or the university will say that, right, that's fine. We are giving you time to cool off. So let's say we're going to give you 4 months to attend to this issue, get some counseling, get some support, and all that. In that case, your visa is likely to be extended for four more months so that you can graduate. So
Okay.
that's an arrangement with the university, and the university will use its own systems and powers to support with that. But you cannot do this willy-nilly, where you say that I want to take a break and come back because the course is too much for me. You can't do that.
Can I switch universities during that period?
The moment you switch university, you have to, of course, get new admission, get new cars, and make new visa application.
So in that situation, do I have to go back to my home country?
Ordinarily, you have to make application from your home country. And
Okay.
therefore, you cannot, that's why you have to make a decision right from the beginning, which university you want to pursue the course with and apply. But whilst you are here, you finish the course, you've gained, let's say, PhD course. Depending on the flexibility the university will allow, the university possibly can assist you. If the same university, then you are transferring to a PhD, you finished and you are moving on to a PhD, the university may support that transfer process in country.
Mhm.
But generally, because you are going to do a new course, you have to go back and apply again. So depending on the circumstance.
Oh, right. Well, nothing is automatic in this country anyway. So,
So
um,
Brakoku, let's look at the other options open to this individual who has not been able to complete the course.
okay, yeah.
We have said that a person, if they have become a parent, can make an application as a parent of a British of a qualifying child, and we have defined qualifying child as a British child or an EU child with pre-settled or settled status, or a child with indefinite leave to remain in the UK.
In the UK, yeah.
So the parent can apply to be considered for 2.5 leave under family applications as a parent of that child. Or this individual, whilst in the UK, has found love in in a lady. And mind you, if you find new love, you have to make sure that you have already severed the existing love you have for somebody. You can't keep both. So let's say you don't have any dependent, then of course, if you find somebody and you, based on your compatibility, you are going to live together, either you started staying together and you marry, or you want to live together, the law allows for that. So let's say you find this lady or this man, you've become you enter into a relationship and you marry. You can then make an application based on your relationship or based on the marriage relationship with this person. Again, there are two gateways. The first gateway is where there is a child involved, i.e., the person that you've married has a child, and you are a stepfather or a stepmother to this child. In this case, there is a child involved. So once you make your application, your request is mainly based on the child's welfare, and therefore you are seeking consideration so that you can remain in the life of this stepchild of yours. If there's no child involved, then you're only applying to remain with your husband or wife who is a British citizen or who has indefinite leave to remain.
Mhm.
Now, in this case, the law will tell you that, oh, I mean, the caseworker can't tell you that, you know what, after all, you are both in love, and it doesn't really matter which part of the world you live to enjoy such love. So go back to the man or the woman's country and enjoy your life as married couple. You don't necessarily have to live in the UK to enjoy. But then the person will argue that my husband or wife is British. They have a home in the UK, and so they have the right to remain. But the law also doesn't say that your British husband or wife has a right to keep you. And therefore, if you want to remain with them, you can go to your country and live and have your. But you should be able to prove then that there is what we call insurmountable obstacles,
Okay.
or there are some obstacles in the way that can never be overcome if you were asked to leave. And because of that love, your husband or wife has to follow you. If they follow you and because of this they cannot survive, and here what are those insurmountable obstacles? It might be that they have serious health issues and they are receiving treatment in the UK. And actually they were happy to have you around them, and eventually you married so that you can be part of the care they are receiving, so that you can provide physical care, emotional care, and help them to be able to overcome whatever health issues they are having, in addition to the medication or the medical treatment they are receiving. Then the argument is that if you are removed and your husband is going to be left alone, it will affect your husband or your wife's health. So they have to reconsider. Or if you are removed and your husband or wife has to follow you to that country, and that's going to affect their health because of the complications we have talked about, then it calls for reconsideration. So these are the discretionary points where, even though there's no child involved, we have to identify and address so that the caseworker makes the decision in line with that, and not just the fact that you've married a British citizen, husband or wife, whichever. So these are the 2 points we want to address. The second option, of course, is where you have to wait for 20 years. But I always say that if you have other options exercisable, why don't you exercise those options rather than waiting for 20 years?
Okay. Well, interesting scenarios, and I know there are questions that will come up, but I've got one of our viewers and listeners on the line. So let me go on to my friend here. Good afternoon.
Good afternoon, Rocco. How you doing, please?
Fine, thank you. Lasma, can you hear him?
Yes, I can.
Okay. Boss, shoot on with your question.
Yes, please. First of all, I would like to thank you for the education you offered us this afternoon. We appreciate.
You're welcome.
And my question is, I'm a student, but I couldn't further my studies, so I'm home now, and unfortunately, my student visa has been revoked. But
Your
I
student
have
visa
a-
has been revoked.
Yes, please.
Okay.
Yeah, but I have a girlfriend who has an indefinite leave to remain, but I have no child with her. But she is having a son, and she want me to help her with the fatherly responsibilities. And I wanted to ask lawyer, with this case, am I eligible to apply for the 2.5 years as you mentioned earlier?
Okay. So you have a girlfriend, and the girlfriend has a son.
Yes.
Your student visa has been revoked. You're
Yes.
asking if you can get involved in the life of this young person and depend
Yes.
on this young person to apply for your 2.5 leave to remain. Is that correct?
Yeah, exactly.
Yes, lawyer.
It's our brother on the call.
Yes,
Can
please.
you-
I'm on the call, please.
Yeah, he's
Oh,
on the
hello.
call.
Yes. Good afternoon, sir. So, first off, you are making an application, or you are not going in to the relationship because of the application you intend to make. The application
No.
is just a byproduct. That is first point I want to make. The second point is that having entered into the relationship, yes, at this point you are living as boy girlfriend. You are in that relationship, but you are not married to the lady, are you?
Yes, please. No, I'm not.
So if you are not married, the application that you would have wished to make would have been with based on the lady, but your application you want to be considered for on the basis of the child. And what is your relationship with this child? That's the first question. You have to establish a relationship. How does the child call you at this stage?
Okay.
Legally, the child is not your father, your child.
Yes, please.
So if you have become a father legally to this child, and here we're looking at stepfather, then we say that you have acquired parental responsibility within the rules. And being a stepfather, you are in the life of the child playing the fatherly role that the child does not have. So you have taken over the father role. You are doing a lot. And on that basis, you should be allowed to continue in the best interest of this child. But you have to set out that, yes, you are a father at this stage.
Okay.
And what makes you a father is when you are married to the child's mother.
Okay.
But lawyer, let me find out from you if, for instance, this gentleman is in a durable relationship with this lady. They've lived together for a year or more. Can that be used to his advantage?
So durable relationship, we're looking at 2 years cohabitation.
Okay.
If the child is not in the equation, then the application, as I said, will be based on the wife. But this is not a wife, but a durable partner. And the
Okay.
law defines a durable partnership as a relationship akin to marriage.
Okay.
And so the relationship with the girlfriend would have been a durable partnership because they've lived together for 2 years, for example.
Okay.
But we are looking at his legal position with the durable partner's son or child.
Okay.
Would the child call him father or my mother's boyfriend?
These days they say uncle.
Uncle. Everybody is uncle. And not all uncles have the Appendix FM advantage.
Right. Boss, is your question answered?
Yes, please.
Okay.
I'm satisfied.
All right. Thank you very much for your time and thank you for enjoying the program. Please share the link for us, okay?
Sure. All right, sir. Thank you.
Okay. 0739920848, or you can send a WhatsApp message to 0795042278. Remember, we had our nugget, and there'll be a question based on that. So maybe I would want to remind you, an employee has to receive the same daily rate for holidays, irrespective of whether they take it during employment or receive it as a payment in lieu once their employment ends. And that's on there for you. And just keep remembering that we'll be doing our quiz on something like that. This was quoted or based on the case Connor versus Chief Constable of South Yorkshire Police, a 2023 case. 0739920848. Lawyer Charles Asma is here. BWF Solicitors is supporting us to bring you this. Lawyer, there's this question here. Unfortunately, today I'm not able to put some of these texts on the screen, but let's look at that. I have been enduring an abusive relationship, and recently the police came into the house and took me away. The borough in which I live has decided to house me and giving me a three well, okay, let me put it as a house. Do I have to ask for the council to pay for the rent as I have no recourse to public funds on my status?
Right. So this person is an abuse. So there is domestic violence.
Yes.
And I want to believe that the council that provided this temporary accommodation knew the situation.
Okay.
And I don't think the council has notified this person that you have to pay X amount.
Okay.
Because the council knew that they couldn't afford, but for health and safety reasons and to mitigate whatever is happening, they had to rehouse this person
Okay.
whilst they are taking steps to help out. So I don't think the council will come and say you also pay. I suppose you
Well,
didn't
if
ask them
if for
that.
instance the person is taken into private accommodation and the estate agent is running after the person, what happened?
The person did not go into the private accommodation themselves. Somebody took the person there.
Okay.
So whoever took the person has
Should be.
knows their responsibility. So the
Okay.
estate agent will go after that person because they don't have a tenancy relationship with the
With the individual, but
beneficiary.
rather would be with the
They don't have
council.
it with the beneficiary. They have it with the tenant on paper, quote and unquote, the legal tenant. So there's legal tenant or title tenant and beneficiary tenant.
Okay.
The council is their tenant, so to speak. And the beneficiary tenant happens to be the individual whom the council is helping.
Okay.
So before the person takes occupation of the property, the agreement had been in place
With the council, not
with the
with the
council,
individual.
whoever, and therefore they know who to go to in terms of payment.
Oh, okay. Okay. Well, if I found myself in a situation like that, I'll forget about rent.
Yeah, I mean, obviously they know where to go. Even if they come to you, that's why when they come to people, they refer them to the council.
To the council.
Yes.
Okay. But in a situation like this, where the person has no recourse to public funds on their stay, and there's a DV in the situation, uh, if my memory serves me right, and if I am being a very good student, the person could be given indefinite leave to remain by the Home Office.
So that's the extension of this person's request. Of course, they did not ask this question, so we're only dealing with the
Yeah, I'm trying to just
yes,
to
preempt.
figure out external
Exactly.
situations. Yeah.
Now, the reason why this person is considered for support is that they are in that situation, violent situation,
Mhm.
and the law has to step in to support or to safeguard this person. So the person doesn't have recourse to public fund, and because of even the relationship they are in, it might be that that person is the one providing for everything.
Mm.
So they don't even have money. They don't have anything. So that is why the council will say, we are going to provide temporary shelter for you, accommodation for you. So they've been given accommodation. And the moment they are given accommodation, the council will automatically offer them opportunity to go on their discretionary support. So they will be supported in terms of essential living needs or meeting their food and clothing and other things. They will put them on the welfare system.
Okay.
So they will be given something every week or every month to meet other things whilst they are being sheltered. And if it's a case that because your leave was sponsored by the person who is abusing you, and one of the reasons why you still remained in this relationship was as a result of the blackmail that if you dare, I will not renew for you.
Mm-hmm.
And because of that, you still stayed on until now. You have disclosed all this, and therefore the council first off will give you 6 months, and you go on the benefit or the welfare scheme. Then after within that 6 months, you are required to make an application under DV provisions, so that it can be considered for leave to remain. And because there will be nobody to continue to sponsor you, the law will automatically catapult you to indefinite leave to remain so that your case is sorted completely.
Mm.
And your application can also be made under fee waiver arrangement because you're already on benefit by default, having been
Okay.
supported through the council system and also the welfare system for that period. You go on there, and of course, you have to make application based on the fee waiver provisions. You have to prove that indeed you cannot afford your fee. And if you can prove, you'll be given a fee waiver which means that you can make your application free of charge, and the application will be under CDV, as you pointed out, indefinite leave to remain. But
Okay.
there are checklists, and you have to make sure that you meet all the criteria.
Oh, okay. Well, I know the person that sent in. If you have any doubts, the best advice I will give you is consult a lawyer who knows what needs to be done, and I'll recommend BWF Solicitors. They are at 214-218 Tottenham High Road, Seven Sisters. Call them Monday to Friday between 9:30 in the morning and 6 o'clock in the evening on 0208 493 7340 or 077 127 61884. I have one of our favorite viewers and listener who says that take your time and mention the numbers like the pastors do. So I'm going to do that actually now. 0208 493 7340 or 077 127 61884. 077 127 61884. That's BWF Solicitors for you, and we are going to say thank you to them again for being our sponsor. We're live on BWTV, and the program is The Community and the Law. Our guest, Lawyer Charles Osma, and myself will be back right after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back, and we're live on BWTV. We're live on Facebook, live on YouTube, and all the other social media platforms. And I would urge you to pick up the link, share with your colleagues, your friends in your network, on your WhatsApp groups, and the rest of it. And also, when you get on the page, click on the notification button, and so that anytime we put any content on, you will be notified. Sometimes people don't join us for the live feed, but they go back to watch it, and the questions keep coming through every now and then. Thank you very much for doing that, and keep going, keep liking the page. If you're new here, like the page, click on the notification button, and join the wonderful family we have live on BWTV and BWF Solicitors. Lawyer, there's this question that somebody's asking, and I believe I would have to bring it for us to help him. I was told before I can get employment offer in the UK, I need to write IELTS exams. This type of IELTS exams I need to write, is it the academic one or the one that says skilled worker? I'm a bit confused about that, but you can help us. What type of IELTS does one coming in as a skilled worker need to write?
So skilled workers must write the one with UKVI,
One with UKVI.
VI, general training.
Okay, all right. He mentioned IELTS academic. Which one is that?
That's for students.
So whoever is coming into the UK as a student will have to write IELTS academic.
IELTS, but it's academic.
Okay.
But that is a little difficult in terms of the type of questions set.
Okay. Well, the next one here is asking, I am in a divorce. It's not a battle. Is divorce a battle?
Well, that is how he defines his situation.
My partner and I acquired certain assets together, and I want to have my peace of mind. Can I sell my portion to my partner and end it all?
So this person can, by way of consent order, agree. First off, agree how they are going to share their property post divorce, and once that is agreed, they inform the court about it,
Mhm.
and it will be put into a consent order. The court will stamp it, and that becomes the order.
So obviously, then when they have informed the court, the person, the partner, would be able to say that I don't want anything. We acquired it during our thing, so I'm selling it off to you, and I take my money away.
Well, but I don't. So okay, so mind you, if they are selling it, it doesn't mean they don't want anything.
Okay.
What they are saying is they have enough already, so they want to sell it to this person if they wish to buy. But they cannot force the person to buy anyway. Now, whatever it is that they are going to agree on, so be it. Once they agree on how the assets will be shared, either one taking up and paying the other person off, or whatever it is, or they selling everything and sharing the money, whatever it is, that's what they've agreed. It is converted to a consent order, and the court will approve it.
Okay. There's one very interesting comment that has been sent in here. One says, some kids say daddy, not uncle. It depends on what you tell your child. Another person continuing says, daddy, not uncle. He will not be his uncle. It's not a funny situation at all. My son will not call my new husband uncle because I brought him up very well. Well, it was just by the by, so don't take it too serious. 0739920848. And if you want to do that via WhatsApp, 0795042278. 0795042278. The question we have addressed this afternoon on the program is, what are my options if I'm not able to complete my education here in the UK, so I remain as a legal person? Divorce wahala, divorce problems. Well, when it is that you need advice, speak to lawyers who know what they are doing. And one organization I'll refer you to with all confidence and without any hesitation is BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, North London, 0208 493 7340 or 077127618884. Lawyer has graciously given us the two scenarios where you've been reported and where it has not been reported. And what do you do? The options that are available for you. listen, don't leave the situation like that. Do something about it. If you find yourself in a situation where you're not able to complete your education, do something about it. Maybe lawyer would reiterate what needs to be done when you find yourself in that situation before we go for our quiz segment, lawyer. Yeah, what I was asking is if you could reiterate what needs to be done when somebody finds himself or herself in the situation.
I mean, if you find yourself in that situation, please seek immediate advice from an immigration lawyer, and the person will take you through what obviously will listen to your story, explore your options, and advise you on what is best under your circumstance. So it's important that you don't wait till once you know your situation, you know that for whatever has happened, you will not be able to start and complete, or you will not be able to complete if you have already started the course. So it's not like you wait and see. Immediately ask for help. And if it's already happened that your leave is expired or curtailed and you don't know what to do, again, ask for help. It might be that your circumstance already provides or offers opportunity for you to explore. And that is what the lawyer will work with you on to ensure that you are able to regularize.
Yes, and with that, we will be taking another quick break and come back to our quiz. But before then, let me just remind you of what we're going to base our quiz on. And it's about Nugget, holiday pay, and on taking holiday. They says that employee has to receive the same daily rate for holidays, irrespective of whether they take it during employment or retrieve it as a payment in lieu of their employment. So get ready for the question. We will be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing, BWF solicitors. Let us take care of probate.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Comedy 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Okay, now welcome back. Thank you very much for sticking and staying around with us. We're going to the last stretch of our program for today. Remember the topic we have dealt with. You still can ask your questions, send them to our WhatsApp, and lawyer and the other members of staff would look at that. What are my options of remaining in the UK legally if I could not finish my studies? The WhatsApp number is 07950 422780. Well, I'm not going to activate the lines anymore because we're going to a quick segment. Lawyer explained what it is about the holiday pay and your entitlements. Now the question is here. Okay, now let's look at the question we have. Honey was dismissed following a lengthy period of sick leave. It was agreed that he was entitled to be paid in lieu of holiday accrued but untaken at the end of his employment. However, there was a dispute about how it should be calculated. His contract contained a clause providing that pay on termination will be calculated at the accrual rate of 1/365 or 1/365th of his annual salary for each day's leave. The use of the 1/365th formula resulted in his accrued holiday being less than his salaried rate of pay. He brought action against his employers. What is likely to be the decision of the ETA? The options are this. He will receive his full holiday pay. He will only receive his pay as agreed under the contract of employment. He will receive half of his pay. The options again. He will receive his full holiday pay. He will only receive his pay as agreed under the contract of employment. He will receive half of his pay. I know you're thinking through your mind. I'll help you here. Let's go back. An employee has to receive the same daily rate for holidays, irrespective of whether they take it during employment or receive it as a payment in lieu once their employment ends. Go back to the question. Look at that again. Text your answers. Honey was dismissed following a lengthy period of sick leave. It was agreed that he was entitled to be paid in lieu of holiday accrued but untaken at the end of his employment. However, there was a dispute about how it should be calculated. His contract contained a clause providing that pay on termination would be calculated at the accrual rate of 1/365 of his annual salary for each day's leave. The use of 1/365 formula resulted in his accrued holiday being less than his salaried rate of pay. Not understanding, he scratched his head. I won't take it lying down. So he brought action against employers. What is likely to be the result? He will receive his full holiday pay. He will only receive his pay as agreed under the contract of employment. He will receive half of his pay. Okay, so your answers, you can text them 0739920848 or send it to WhatsApp 07950422780. Let's see what you would bring to us. Those of you on YouTube, you can leave your comments there in the chat. Those of you on Facebook, yes, leave your comments there in the chat as well. I'm not going to activate the lines, but let's see what happens. 07. Okay. Before we go on, Laura, let me please pick this question quickly. Can you explain the TD Yemen case law in relation to sole responsibility? Yeah, let's see if we can pick that one up quickly.
Right. So the case law with sole responsibility, especially that of TD Yemen, looks at sole responsibility as a continuing control and direction exercised by the parent in the life of the child with respect to the child's upbringing. What it means is that it has to be something that is regular, that is ongoing, that is continuing. And
Okay.
control here, you making every decision with respect to the welfare of the child, and the direction of growth and development of that child. So it says continuing control and direction with respect to the child's upbringing. So if you are a parent and you are not able to prove that you are the only person who continues to exercise control over the child in terms of where to live, in terms of what name to be called the child, if the child is not already named or they intend to change the name, the religious faith the child can have in terms of the church to attend or the mosque to attend. Again, hospital in terms of health, in terms of financial support, how the upkeep of the child, accommodation, all these things come in, schooling, everything. The child is sick, everything to do with the child who exercises that control, and the control should be continuing. So you can't say that I did it and I stopped it, and therefore I am the sole parent. That means that whoever continued for you is also having parental responsibility. So
Mm.
then they can take up and help the child. So to be able to prove that you are the only parent in the life of the child, your control must be continuing, and it should be in the direction of the child, directing the child's growth and development. So that is one thing that we have to bear in mind.
In mind. Okay. Another person is brought in, I think, just before we answer the quiz question briefly. Um, the person is booked leave. It has been authorized. On the company system, it's on there that the person is booked leave. Bought his ticket, is ready to travel, and the situation changes. What action can he bring against the manager that authorized the leave and is now saying, no, you can't go?
Right. Remember we talked about leave based on the needs of the business. The employee is supposed to take leave,
Yeah.
and the the date and the duration of the leave should be in consultation with the employer or the line manager.
Mhm.
So the line manager will agree that yes, it's fine for you to go, or it's not fine at this stage and therefore wait, or it's okay, but you can take X number of days or this long. If that is discussed and agreed, mind you, we are looking at who has whether it is taken in totality. So this person is saying that they agree, they agreed with with the one of the managers,
Mhm.
and later on, the manager's manager, who has the final say, maybe said that it is not right for you to take the whole leave at this time. Maybe you are taking too many days, so cut it down. Can I sue or can I do anything? To be fair, whatever the holiday is in the interest of the organization. So what the person can actually say is that, well, because I was given the permission, I bought my ticket costing X amount. If I'm going to cut my holiday, sure, I was supposed to go for X period for whatever reason.
Mhm.
So I'm going to lose out because of this change. I'm happy to go by the needs of the business. But at the same time, if the business can meet me somehow, because it wasn't my fault that
So
I.
it would have be negotiations, kind of.
So in this case, negotiation will come in. But if the manager's manager says you can't have it, that means the manager got it wrong from the beginning.
Serious case. Anyway, I think probably another time, because we're running out of time. Another time we'll come and look at this in full. But the on our quiz, this person signed an employment contract, and they said in the employment contract that if the situation like this arises, we're going to pay you 1 out of 365. Now they calculate that, and it's not up to what probably the law says and what the person is entitled. But he signed a contract. So would the person be right or wrong? What would be your answer? Yes, La. What would be your answer?
Right. So we're going to allow viewers to.
Well, I think we my technical bit is preventing me from picking up the text and the rest of it. So for this
Right.
one, I will ask you to help the class and give us a bonus.
Okay. That's fine. So, okay. Um, if we look at the nugget
Yeah.
carefully, you can just take us back to the nugget. What the nugget says within the law is that if an employee has to receive, so an employee is supposed to have the same daily rate for holidays,
Mm-hmm.
irrespective of whether they take it or not, and whether in lieu of termination or not. So the same daily rate of holidays. What this means is that if you go on holiday, it means you are working, and that point you have to be paid salary. Now, it's a technicality. Let's note this technicality. If you go on holiday, you are going to be paid as if you are working, aren't you?
Mm-hmm.
What it means is that if you are not on holiday, you are already getting your salary. So if you are saving your holiday deliberately so that it is paid to you or converted to cash, then you are going to get double salary, so to speak.
Mm-hmm.
That point is noted.
Okay.
Now, the contract and the law are there. So the statute, the case law, we're also looking at the employment contract with the employer, between the employer and employee, which is the starting point. What does the contract say, which the employee has agreed to? Says that if you choose not to take your holiday for whatever reason, you are not going to get everything so that you be better off. You are going to get 1 out of 365 of your salary for that holiday aspect. Now, this person we calculate and we realize that, so if you go back to the question, it is calculated and we note that, or the person feels that the holiday bit, they are losing out. More or less, oh, I should have taken my holiday. If that is what is going to give me, then I should have taken my holiday. Can I take the company to court? If you take the company to court, what is going to happen is that they're going to tell you that you have to receive the pay agreed within the contract. So the contract says that you are going to get 1 out of 365 of the annual salary for the holiday that is accrued. So be it. You can't say that I have to get full. You can't say I have to get that. The court will refer first to the employment contract before making reference to any other statute or case law. And the contract is clear. And therefore, the answer is number two. The person will receive his pay as agreed under the contract of employment.
Yes, and that's what Laura has mentioned to us. Obviously, you signed your contract. Taking of annual leave is important to fulfill the health and safety purposes underpinning the Working Time Directive and the WTR. How holiday pay is calculated is important to the extent that the purpose of the legislation would be undermined if pay was anything other than usual pay, as workers would not be inclined to take that leave if it meant their pay would drop during it. Well, it's the same case, Connor versus Chief Constable of South Yorkshire Police, 2023. And with that, we come to the end of our story for today. And tradition as it is, I'll give Lawyer the chance to do his brief summary. Then I will draw the curtains down and say thank you and bye-bye to you again. So, Lawyer, over to you.
Thank you, Brakuku. So, viewers and listeners, today we've looked at what do I do if I'm a foreign student in the UK and unable to complete my course. The law now is that if you have not been able to complete the course, you cannot switch to skilled worker route. So that is out. What options do I have? In this case, you have to prove that you are a parent of a British child or EU child or a qualifying child, so to speak. And so you want to make an application under Appendix FM for 2.5 to be able to remain in the life of your child. Or whilst here, you marry. If you marry, then depending on the situation of your wife or husband, if your wife or husband has a child, then you become a stepmother or stepfather. In this case, you can apply based on the child, who is a qualifying child. Because of the child, you have higher chance. But if it's just with you and your husband or wife, then the law will look at something more pressing than just the human person. And therefore, something more pressing could be health. Another thing that will prevent the British person from leaving the UK with you. And on that basis, there is insurmountable obstacle. Otherwise, even though decision will be made, but it's always the case that the caseworker will be inclined to say that the two of you should relocate to your country and live your marriage life. Now, in terms of the child, as we said, if you are a wife or the woman with the student who cannot switch and you are going to switch around, then of course you can, as a dependent, convert your dependent leave to skilled worker leave so that the main person can become your dependent. At the moment, the law is flexible on that arrangement. But if you're a woman and you have a child and you have not divorced your student husband, then the child that you have with a British father is for the student husband. And so what the student has is what the child has. And you can see that you are back to square one. So to be able to take advantage of your child's status, you should have divorced your husband before you had your child for the child to be a qualifying child. So this is the conversation we've had today. Otherwise, you have to wait for 20 years. And if the law still hasn't changed, then you can rely on 20 years long stay to apply for leave to remain 2.5. If after this conversation you need further assistance, do not hesitate. We are always available to support and to give you tailored advice and direction. It is not too late. Take action. Thank you.
It's not too late. Take action. Make sure you do the right thing by visiting BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors. We are at 214-218 Tottenham High Road, Seven Sisters, 0208 493 7340 or 07712761 Thank you very much, Lawyer Charles Asma, for your time, for your share of knowledge. And to BWF Solicitors, what can we say? We're so ever grateful to you. We are eternally indebted to you for the ton of knowledge that you have sharing with us. And we are so sure that same time next week, when we come over again to the same platform, we will meet you and you'll be giving us exactly the same quality as you have always been giving. So on behalf of Sheila Ankra, Padmo Dudu, Cynthia Brown, and the BWF Solicitors family, Lawyer Charles Asma, Lawyer Eunice, and the principal, Uncle Ben, want to say thank you very much for your support all throughout. We'll be back again same time next week. Until then, be good and God bless you.